Okay, it is 8:30 p.m. and welcome to week 3 of Introduction to Criminal Law. And I'm Richard Wright, your instructor. And for the next hour, I'm going to share with you what assignments, what things that you have to do for the course of this week. I'm going to go over and give you some things that I've noticed that you guys have missed in the first few assignments. Like, for example, you didn't read the instructions carefully, because if you don't read the instructions carefully, you won't get all of the points that you need. And I started in day 1 explaining that it is critical to follow the instructions to make sure that you get all of the points. And so what I'm going to do is I'm going to go ahead and get started right away, and I'm going to share my screen. And there's my little mug shot there, and you know the rule. You can call me, text me, email me any hour of the day except the 25th hour of the day. And you should figure that one out by now. And then there's some additional, of course, information here. But I want to go down specifically and remind you about rubrics, which as I go through the assignments, you'll see. Lectures 1, there's a link there to it, which was the lecture 1. Lecture 2, there was another link to it. And then tonight, following this lecture, I will do the same exact thing. And then after this, you should be aware that we have a lecture next week. And then we'll have the last one in this class in week 5. It'll be on a Friday. So it says it right here that, weeks 4 and 5, rather. 1, 2, 3, 4, and 5 will be at the same time. Correction, week 6 lecture will take place on Friday, May 4th, which is actually the end of week 5, that Friday, because your course ends, as you already know from the calendar, on May 8th in this class, since this is a 5.5. And I said last week that we were 1/3 of the way through. We have 2/3 going. So now I would just basically say that now we're at the halfway point with completing week 3. And then we have just 3 more weekly assignments that have to be done. Very important that you keep those assignments up. Very important that you pay attention to the rubrics. Some of you have not done the assignments, especially in week 1. I finished grading every one of them. Week 2, I will be working on them. And by the end of the week or the early part of next week, you'll see those graded. But at any rate, it is so important that you make sure that you follow the information that I give. So anyway, without any further ado, let's look at our week 3 announcement. So in the 3rd week this week, we're going to deal, last week we dealt with crimes against property. This week we're going to deal with crimes against persons. And don't necessarily equate the key word that I gave last week to this week, because it doesn't necessarily mean that you say, aha, I think I already know what the key word is. Wrong. It may not be that, but don't try to assume. That'll mess you up. So anyway, you're to read chapters 4, 5, and 6. I'm going to briefly go over those. I previously sent you the PowerPoints to help you prepare for this week's assignments. And then a brief introduction to criminal law. That's the book that you're using. And then complete the activities relating to homicide, battery, domestic violence, sexual assault, and then sexual assault crimes, key terms, and then for practice, special circumstances relating to homicide classifications. And then, of course, you have this practice quiz. Now, keep in mind that this week you will have one of the 2 quizzes that will count as grades. And we're going to be talking about that in just a few minutes. But you should not forsake the practice quizzes. As I already stressed, previously in my lectures because they're important with giving you the details of how to prepare for the graded quiz. So this week, as normally, you have discussion assignment that your initial post, what type of homicide is this, is due tonight, 11:59 p.m. Central Standard Time. I've looked at some and made a comment on one. I will be doing the same tonight. So Tuesday, 11:59 p.m. Central Standard Time, and then your reply post on the same topic is due Saturday. Again, I encourage you to reply to as many posts as possible. Many of you have done so, and also make sure that you pay close attention to the rubric on discussions. But I've given some really good guidance. I look for detailed posts. I also like extra posts. I also like it when students respond to my posts. I like you to know that to maximize it, you put quality posts together with on time, because if you are late, you're going to lose points. Then, of course, if you submit posts, as some of you did in week 1, that were after the forum ended, you don't get points for it. And I said that during the open house, plus that's indicated in the syllabus and is a school rule. And so I have to abide by that. Finally, complete the written assignment, spousal rape. Spousal rape. You're going to go through the scenario, and I'm going to go through that in just a little bit. Then there's the quiz, which is timed. It is a time quiz. Now, both of those are due Sunday. I highly recommend that you don't try to do that quiz until you've gone through the material. You must get that quiz in by 11:59 p.m. Central Standard Time. If you don't get your quiz in on time, it's going to be late, and I'm going to be deducting points. If you, for example, got your quiz and you got a perfect score, you're going to lose some points because of it being late. And so it is very, very important. Now, the way that I grade papers is I look at and see if you just, there are students who just missed the 11:59 deadline. I give them what we call a little mercy, grace and mercy break that lasts usually for about a half an hour, sometimes up to 45 minutes, depending on the circumstances, that I will not deduct points for late assignments. And so anyway, make sure you do that. And then my motto, I've already shared, adversity is a springboard to success, and what that is all about. So let's take a look at our course calendar. Okay, here we go. Let's go over to it. Okay, and it tells us right where we are. This is the week of the 16th, and so this one is not your calendar. Let me go down to it because this is checked off. So let's get rid of that. And now let's check the right calendar. Here it comes up now. There we go. So anyway, so let's move this back up. Okay. So here we are for this week, and what your assignments are, just what we went over, the reading assignment, your initial post, your lecture, and then your reply post, and then your written assignment. Notice that it's about the spousal rape issue, and then you're going to follow the rubric. And then, of course, the other thing is a reminder about the timed quiz. okay, as well. And so that's your assignment for the week. And you want to make sure that you get them in on time, okay? So now let's go back to and take a look at the module. Okay, here we are. And now let's get into week 3. And first, let's again go over the assignments. Again, there's no excuses that any of my students ever have about their assignments. I'm going to make that a little bit smaller. There we go. So your discussion posts, we already went over that. And you're going to determine what type of homicide it is, given the fact that it is a homicide, but you're going to determine what should he be charged with. First-degree murder, involuntary manslaughter, or voluntary manslaughter. It's going to be one of the 3. I already know which one it is. Some of you have already picked up on it pretty well, but not only do I want you to pick up on it, but explain. Give me some support as to how it applies, and explain which criminal law is applicable to this case and why the others don't apply. So that's your initial post. Then for your reply posts, examine another student's post that may contrast with yours. Now, this one might be a little harder to do, but at least try to find some. Look through them. Consider all potential criminal charges. Explain why you feel strongly about one of the crimes and versus another. Okay, and so you want to make sure. And then you need some help with this. You can go to our Justice Studies Guide, and it will provide you with some resources. There's a link right there for you. Okay, and then your written assignment, spousal rape. And this is a 2-part assignment. First, examine the types of crime. Now, see, students need to make sure that it is not one or the other. You got to do both of them. In the first week written assignment, some students got trapped by thinking you picked one of the 3 scenarios. No, it wasn't. It said all 3, and it was part of the rubric as well as the instructions. You have to be very careful and read it. So in this one, it says crimes against people, including the degrees of homicide, battery, domestic violence, sexual assault. And in this assignment, you'll apply sexual assault laws to a real-world scenario, and then consider what type of interview questions you would ask the individual. That's in the second part. So you're going to look at the scenario here, and then you're going to complete these questions. Now, is this part one is a minimum of 2 pages, not counting the reference page. I do run your papers through Grammarly. Only a handful of you got caught with that, but most of you did pretty well with that. And when I do that, then I'm encouraging you to make sure that you include more critical thinking. I'm more interested in that in your written assignments. And then complete, like I said, the 2 pages. Now, so you're going to be graded on that part. And then the interview, you'll consider what type of interview questions. And then, here's the scenario for that. To complete this, a minimum of 1 page. So you're going to need 1 page for 2 pages for the first part and 1 page for the last part. Okay? And, the point of the matter is you can actually put it together. You don't have to have another cover sheet. If you decide to do it, you can. But, you can, like, for example, say the type of crimes committed and then do the 2 pages. Or then you can have another cover sheet that says the interview. It's up to you. It doesn't matter. It doesn't matter. I will be looking at it first, and then I will follow with the rubric and giving you comments about what you did right and or if you did something wrong. So you're going to explain how you'll approach the interview with Jackie and what sensitive questions you ask in order to determine the nature of the assault and what happened. Again, we provide you with some assistance. There's that guides again. And, you make sure that you do well in terms of each of these assignments. Now, going back to this, if you click on the assignment, it's going to tell you the due date, which is this Sunday, the 22nd. Okay? And it's going to tell you the possible points are 40. And it reminds you, too, that, if you look at the rubric, which I encourage you to always look at it, it will tell you how you do it. For part 1, it is 15%, 15 points. And that's meets, do all the things that it says in here in order to satisfy to have all of these points. Then conduct the interview. That's the second part. You get 15 points for that. So you get 15 for each one, even though one's 2 pages, one's 1. But that's how we balance it out. That's how I laid out my rubric. Okay, let's go back to it. So now let's go, whoops, when I click that, okay, let's go down to, and then, of course, my organization, making sure that your sentence structures are correct, and you don't have big grammarly hit either. And then your APA citations, make sure you have your citations and references, and then your credible sources. So you'll become familiar with this sections because that's pretty much the same thing I do with each of my weekly rubrics. And you'll lose points if you don't do the whole thing. And so for a total of 40 points in order to get a perfect grade. Okay, so that's the assignments, and you want to make sure that you do that. Okay, let's go back. And then keep in mind that you've got the quiz, and I'm not clicking on that. It is a 30-minute quiz. 30-minute quiz. And, it's timed. And you'll be notified when 1 minute, when 5 minutes, and then 30 seconds. And remember, you're abiding by the academic misconduct policy. In other words, you're not supposed to have materials. It's a closed book exam, okay? You're not supposed to have an outline or any of that. And then, of course, your live lecture today, you want to make sure that you, if you didn't attend a live lecture, that you do provide me with the key word by the same time your assignments are due in order to maximize your points. Otherwise, you will lose points for each day. So I believe it's 5 points, but if at the next day, for example, there was one student I know that submitted it on that that Monday, you lost 1 point. If you did it at Tuesday, you lost 2 points. If you did it on that Wednesday, you lost 3 points. And so then, it's not good. So the key thing is to do it in the week. Besides, it's important that you do it in that week because it helps you with your assignments as well. Okay? So now let's go back. And let's go and spend some time dealing with the lesson content. So today, as a little differently, crimes against people. Now, I preface my lecture on the content here by reminding you that you will discover that the law issues or doles out more severe penalties for crimes against people and persons, because life is precious, and property can always be replaced. And so therefore, yes, you can receive time, be incarcerated for a length of time, depending on whether it's a felony. Again, if it's over a year, it's a felony. If it's under a year, it's a misdemeanor, and it's a less severe offense. But crimes against people is punishable more severe. We want to try to discourage you from hurting people, from creating injury to people, you know, and those kind of things, from killing people. So we're going to distinguish between homicide, voluntary manslaughter, involuntary justifiable homicide. And then we're going to talk a little bit about battery, simple battery, substantial battery, and the last two apply traditional crimes against persons to domestic violence laws, of which I'm always very interested in, and you know why, because you heard my story about my life that growing up in a home of domestic violence. Identify the degrees of sexual assault crimes as well, okay? And again, these are the assignments. So I'm going to go on right ahead, and I'm going to start with homicide. Now, when you take the life of a person or they're killed, that's homicide. And there's lawful homicide and there's unlawful homicide. Now, so that means that you don't always go to jail for homicide. If it's lawful homicide or justifiable homicide, you don't go to jail for. But the burden is on the defense to establish that if there is an argument of justifiable homicide, that you have to be able to prove that. It is also possible that that is also done on the prosecution side. So what I'm saying is, if a person, for example, alleges self-defense, then in that case, as a defense, then that could result in justifiable homicide, depending on all the circumstances, some of which we will go over. A lot of it is included in your reading. And then the same thing with law enforcement. When the correct amount of force is utilized, then it's justifiable. When it's excessive force, then it becomes unjustifiable force and could be homicide that could result in a person being prosecuted, and that happens occasionally with law enforcement as well. So it says here that when police officers have to use deadly force to prevent great bodily harm or death to themselves, the homicide is generally deemed lawful or justifiable. So in contrast, when, for example, an upset boyfriend intentionally kills his girlfriend because he believes she has cheated on him, the killing is unlawful and is referred to as murder. And we'll explain why, because the key here is intentionally, okay? Therefore, murder is the unlawful killing of one person by another, okay? So we're going to take just a brief look at these definitions here. So, I mean, in some jurisdictions, they don't have degrees of murder, but let's take a look at what generally is considered as first-degree murder. And this is utilizing Minnesota. It says it's set apart from other degrees because the killer not only demonstrates premeditation, that is, that they planned it, they thought about it. We call forethought. And then they intended purposely. They had a target. And forethought of an intent, and it's a common way of saying that that person was malicious in terms of their offense. So the points are: they caused the death of another human being, premeditated with intent to kill that person. Those are three elements that are necessary as you learn here. Okay? As stated in first-degree murder cases, intent must be demonstrated. For example, if it was determined that the killer had told another of the intent to kill the victim, and in fact comes out of the action, the previous statement could be used to determine intent. So in other words, when you tell somebody something, that statement could elevate it to satisfy the intent requirement, okay? So, and then sometimes it's more obvious, such as when the killer screams, "You're going to die," and then kills that person with a gun or whatever. Evidence of motive could also be uncovered to show that the killer intended to kill the person. For example, there may be some previous written communication, email, texting, something recorded. Persons hear them make statements and in their presence. In that case, it is not hearsay because they were present to hear. But if someone told them that they heard, then it becomes hearsay, indicating that the killer planned and intended to kill the victim in an effort to collect insurance money and so forth and so on. So that's first degree, the more serious. So then there's second degree. Second degree actually sometimes goes into close to manslaughter, lesser degrees of murder, to address instances when premeditation can't be proven. For example, the jury is instructed in Colorado that second degree includes the following facts: the defendant in that state at the time and place knowingly caused death of another person. Knowingly. In other words, you should note that the element of second degree murder doesn't involve premeditation, but they did something that they should know or should have known would cause the death of an individual. But they still include the intentional killing of one human by another. And as I said a few minutes ago, in some jurisdictions, that's considered as manslaughter or voluntary manslaughter. It's not first degree murder. So that's why in some jurisdictions, then you will find murder and then manslaughter or voluntary manslaughter and involuntary manslaughter, because that's usually the same as second degree murder. When the killing is done without prior intent, but it does occur in passion, in the heat of passion. So the person loses control, and then they kill the person. Oftentimes, and then remember this, the sentence is less for second degree murder or manslaughter than it is for first degree murder, okay? But the passion issue is the thing that we look at here, the passion issue. Now, remember one thing, they did kill that person, went too far, and when it was applied in murder cases, at the moment that it says it causes irresistible impulse, it would be difficult to lessen the 70s. Here's the severity of murder under this concept. If Bob came home to find his wife in bed with Jim, but then hunted Jim down the next day and killed him. If he did it, though, at that time, it would probably be voluntary manslaughter as opposed to murder. But if he, as it says, if there's some time lapse between that, then it's considered as murder. So the key thing is that there's some planning involved. The state of Tennessee says voluntary manslaughter is the intentional or knowing killing, or you should know killing of another person in a passionate state and produced by adequate provocation sufficient to lead a reasonable person to act in a rational manner. So again, like for example, walking up on a man in the bed with your wife and then you take a gun and shoot and kill both of them, probably it would be second-degree murder or either manslaughter, voluntary manslaughter. Okay, voluntary manslaughter. You'll see the difference in a minute here. So then we get the first, these special circumstances. I'm not going to spend a lot of time with this, but there are aggravating factors as to whether something is first degree or second degree. Future dangerousness, the probability the defendant would commit criminal acts of violence that would constitute continuing serious threat to society. It was a vile action. And then second degree, you get to the point, two common circumstances, and you notice when the circumstances exist that may deprive a reasonable person of self-control. For example, comes home and finds this person in bed with the person's wife. And then enraged, he shoots and kills the person. So Bob would likely argue adequate provocation in these instances, second-degree murder, which may be an appropriate charge in some states, or voluntary manslaughter, and then the coercion thing. So let's move along because we got a lot of material to cover here. Let's talk about involuntary manslaughter. Okay, so now involuntary manslaughter is the lower of them. It says when a person kills another, but there is no malice, there's no premeditation, no evil intent, but something recklessly is done that causes the death. For instance, a person who drives a car recklessly or speeds may be guilty of involuntary manslaughter, or violating similar laws such as reckless homicide, driving while intoxicated in a drunk driving case. The defendant didn't try to kill anybody, but the careless act of that individual is almost like tortious. But for the fact that that person was drunk, driving a vehicle, that person resulted in killing others. Okay, and so therefore, involuntary manslaughter. I had a few of those kinds of cases. And usually in those kinds of cases, we end up working some kind of deal out or plea where that person ends up, a lot of times the two that I had were alcoholics. And one of them was a real dear friend who was killed in the accident coming from a party. And there was what they call reckless homicide. But the point of the matter is it would be considered as involuntary manslaughter. Utter disregard or utter indifference for human life is defined as a course of action which shows actual or deliberate intention to harm, or which, if not intentional, shows an utter indifference. In other words, no consideration given, or conscious disregard. In other words, just not paying attention for the welfare and safety of others. Reckless simply means to be indifferent or careless in the welfare of another person. So either way, you're still going to find yourself in an involuntary manslaughter. So which degree of involuntary manslaughter? Here's a case that talks about involuntary manslaughter and how it applies. This one involving Jim. And I'm not going to take time to go through it, but you can look through it and you can see. But here's the key thing you're going to be looking for is, was it intentional? Did it happen accidental? Was it in a situation where the person found themselves operating under the guise where they just neglected doing something? So this is a car accident deal, like the one I talked about. So you could take time and go through and look at that. Then there's what we call one-punch homicide. I know about that. When in battery cases where a person can knock a person down, they can bump their heads, they can find themselves in situations. And if you play these clips, you'll see some examples. Let's see if I can just do one real quick. No, I'm not going to do that. It's not going to work because I don't want to go through the signing in. But you could check it out by looking at these. But involuntary manslaughter can occur in the context of battery cases. And that's discussed in another lecture. But the term one punch has been used to describe instances when a person intentionally batters, that is, punches a person, but that one punch results in their death. Now, I'm not talking about somebody in a boxing ring, because there's a tortious theory called valente non fit injuria, a Latin phrase, which means that you should expect to be hit in that kind of a situation. We're talking about where a person might accidentally punch a person and they hit their head or hit the ground. I'm giving you some information that's actually involved in your assignment today. And you start to say, okay, which of these it fits in? And every time you're going to find, because it's not malicious, it wasn't done with intent, and it was basically accidental, but all the things that occurred resulted in the death of that individual, which in most cases would result in involuntary manslaughter. Okay. Some of your reading material and the PowerPoint. So let's get into battery. Let's talk about battery for a little bit. So what is battery? And pretty much it's basic unwanted touching. So there's what we call simple battery, which is a misdemeanor. It's typically charged when one intends to batter another and causes a minor injury. A minor injury. Tripping someone might be a battery. Slapping someone might be a battery. Punching someone, but it doesn't result in serious injury, might be a battery. Pushing someone. The main thing is you make contact. In contrast, substantial battery, which is a felony, involves using some kind of weapon, or even if you're a registered boxer or you're a person who is registered in the martial arts, that ordinarily, which would be a battery for many people, would be an aggravated battery or aggravated assault, and it could result in serious injury. Therefore, you could find yourself in that. But the column elements of battery just simply, it's done on purpose. It's not like you accidentally touch somebody. They injured. Now, it depends on the extent of the injury, okay, without consent, all right? Is kissing someone battery if they don't want to be kissed? Yes. Is hugging someone that doesn't want to be hugged? Yes. But you said, but I didn't injure them. Yes, you did. You can psychologically injure people. The bottom line is that the intentional act that results in an injury, now the crime might be de minimis in terms of the sentence you get, but the point of the matter is the elements are still there, okay? So let's talk about assault. Now, usually you hear people refer to assault and battery. And when they say assault, assault is something that precedes a battery. For example, if I raise my hand like I'm going to hit you, and creates a belief that I'm going to hit you or harm you, then that is the assault. It says here in bullet point number 2 involves no physical contact unless assault is specifically defined, as in, like in Utah. They say in Utah, the example. In some states, battery may be referred to as an assault. For example, state of Utah is analogous to simple battery, and it's called assault, which is unlawful force or violence that causes bodily injury. However, assaults generally don't result in touching. Assault and battery are sometimes synonymous, but are actually definitely differences, and that's what I'm explaining. So you don't have to touch a person to be charged with assault. Battery is when you do make contact. That's pretty much what it comes out to be, all right? And so states vary about it and those kinds of things. Bodily harm, depending on the jurisdiction that you're in. For example, in the state of Wisconsin, physical pain or injury, illness, or any impairment or physical condition. And depends on whatever state. It's interesting, we got Louisiana in here, which says they use the Napoleonic Code. Serious bodily injury has to be involved there interchangeably. Mayhem, as said, is the most serious type of bodily harm and is involved in California. Every person who unlawfully or maliciously deprives a person of being a member of this body, or disables, disfigures, or renders useless, or cuts or disables a person, disables the tongue, puts out an eye, slits the throat, nose, eye, ear, throat, is guilty of mayhem. Mayhem is consistently defined across the country. And basically what it is that you may have poured lye on someone, you did something to disfigure them, and that's serious bodily injury as well. And so I'm not going to go into this scenario here, okay? So now you know about battery. So now let's spend a little time talking about domestic violence. Now, domestic violence is probably one of the most serious offenses that takes place on a regular basis, but is not as reported as much as other types. In jurisdictions, generally, the domestic violence attaches to something else, another crime, such as battery or something of that nature. It could be murder. But the point of the matter is, if battery happens within a relationship of someone, doesn't have to be married, domestic relationship, and it pretty much defines now individuals who you live with. It's something that takes place in the home generally, where people reside together, coexist. The criminal charge is battery and domestic violence, which enhances the battery. So if it's a misdemeanor battery and it's domestic violence, it then elevates, because it's domestic in nature, into a felony. And it carries more serious penalties. Why is that? It's because the fact that you should be aware that there are people who are in their homes and they are not respected or abused. Their rights are taken away. They're treated like children if they're adults. They may be beat physically. There may be also verbal as well as physical abuse is domestic violence. So it says here there isn't one accepted definition. The National Coalition Against Domestic Violence defines domestic violence as the willful intimidation. See, that's what I'm talking about. That's psychological or speaking. Physical assault, battery, putting that person in danger, threatening them with a gun, for example, and showing them a gun, for example, that kind of thing, showing them a knife, showing them a weapon, sexual assault, forcing that person to have sex with you under duress, and or some other abusive behavior and as we have said time and time again, it says, and the word power is in here. It says as a form of systematic pattern of power, and it is what it actually boils down to is the individual has power over that individual. Having grown up in a home, seeing a man beat my mother profusely and really, really bad. Um, he had control over her, and there's what we call a cycle of abuse, which since it's not a domestic violence class, I'm not going to go into details of it. But what it amounts to is this: is that the person becomes a victim, and then that person might be arrested. That person will end up engaging back with that person following that, give them another chance. That person will say, I didn't mean it, I'm sorry, I lost my temper, and those kind of things. I used to have the person who would beat my mother. It was so dumb. He knew I liked Twinkies as a kid, and he would buy me Twinkies, not to shut me up, but to try to let me know he really wasn't such a bad guy. I took the Twinkies, but I still recognized this dude was not right and he was bad. But so the bottom line is that it's a power issue, as a systematic pattern of power and control perpetrated by one intimate partner against another. That's kind of like the standard across the board definition. State laws require, in order for domestic abuse case to be prosecuted successfully, the crime must have occurred within the context of a domestic relationship. And in most states, a domestic relationship exists of the crime, such as battery, occurs between two adults, at least 18 years old, who live together, that is, intimate partners, have lived together or have a child in common. And if the domestic relationship exists, then the offense of battery would become domestic violence because it happens within the domestic relationship. And those are kind of like some of the general elements. It can take many forms, as I said: physical violence, sexual assault, emotional, economic harm, such as taking that person's money and not allowing them access to their money. Other crimes within a domestic relationship, in most cases, when law enforcement is called. And let me tell you, as a police officer, I can tell you this, that one of the worst calls that we actually were engaged in, and I remember we were told to watch everybody. And the reason why I say that is that, give you a scenario that actually happened. We were called to a domestic violence call, and so when we got there, we could see the house was in disarray. The woman let us in, and when we came in, we went and got the guy, and we were, taking the guy, putting him in cuffs, and we were required under the law to take him out of the house. But here's what we were doing. We were putting the cuffs on, and when one of my partners was putting the cuffs on, the woman jumps up and says, "That's my man. You don't, be careful. You don't hurt him." And we were looking like, huh? And she was ready to pounce upon the officer that was doing that, but we had to keep her at bay. So what I'm saying is that in those situations, it can be such that the person who is the actual victim that called can attack law enforcement. So it says that when law enforcement is called to a domestic violence incident, physical abuse, or battery has occurred, although the definition of domestic abuse discussed above is so broad, in its most specific form, a criminal law perspective, when investigating domestic violence, the law enforcement also must determine if the act occurred within the context of a domestic relationship. And if that's the case, then. And then there are things that people can do, get orders of protection, go into court and stuff like that. From a domestic violence perspective, the definition of a domestic relationship in most states contain at least two adults, in most states, at least 18 years of age or older, who live or have lived together or have a child in common. So it doesn't require marriage. Some people think that. Okay, and then they have various different states, such as Alaska expands the definition even further to include adults or minors who are current or former spouses, live or have lived together, or who are dating or have dated and have engaged a sexual relationship or have a child in common. That's Alaska code. But the key thing is that law enforcement officers, as they say, properly know and apply the definition according to the jurisdiction they're in, and make the proper arrest then. Okay, so I'm not going to go into enforcement of most criminal laws allow officers to use discretion and the best way to resolve it. However, there are certain steps that now have to take place, like taking that person out of the house, and then mandatory arrest laws in some jurisdictions direct police officers to make arrests where probable cause exists. You see all the surrounding circumstances. You can see the place. You can see the person may be bruised or injured in some form. Then you can make an arrest based upon that. That's adequate probable cause for an arrest. And then there's some more details if you clicked on this and those kinds of things. Okay. All right. We got not much more time. Sexual assault crimes. Sexual assault, commonly referred to as rape, is the act of unlawfully forcing a person to have intercourse or sex with a. Now look at what it says. At common law, it was the act of unlawful intercourse by a male with a female other than his wife without her consent. Well, today it's different because male, male, female, female. Today, rape is more appropriately referred to as sexual assault and is gender neutral, as I just said. The victim may be of either sex, may also include spouses as well. Sexual assault doesn't require that the intercourse take place, but includes unlawful touching, no matter how slight, of the person's private area or genitalia area, and without their consent. Sex crimes are commonly referred to as sensitive crimes due to their obvious nature. It is imperative these investigations are handled with the empathy that police officers are. They're police officers that to understand, and with the fact now that we have rape shield laws, which rape shield laws involve the fact that when a case comes to trial, that the person who's the victim, you cannot use their sexual activity against them, as commonly was used by defense attorneys for years and years and years. And I can tell you that I didn't like to do them. I didn't do them. I did only one real rape case, and that was a person who cried rape after a person she was dating announced he was going back to his wife. And so anyway, I had a trial before a judge, and the judge, black female judge, found the young lady was not credible and found him not guilty. And so anyway, they're very sensitive. People don't like to engage in bringing rape charges because of the way that people themselves are treated. So we're going to spend a little time talking about that right now. So sexual assault is when you have time is of the essence because the physical evidence such as DNA can disappear. Another aspect of investigating these cases for law enforcement is to consider properly apply the elements of the sexual assault offenses to the facts of what was taking place, aware of the elements and comparing them to other facts in the case. But like other crimes against persons, sexual assault cases are sometimes categorized by degrees. Okay, and so there's some states that have first degree sexual assault, and it'll describe what that is. It says the victim is under 13 years of age, and the defendant is more than 3 years older than the person. The victim is 13 to 16, and the actor is more than 4 years older than the victim and in a position of authority over that person. The circumstances at the time of the assault placed the victim in reasonable fear of physical harm. The defendant was armed with a weapon and threatened that person if they didn't have sex with him. Defendant caused injury to the victim. Defendant used force or coercion in sexual penetration. The victim knew or had reason to know that the victim was mentally impaired, taking care of a mentally advantage of a mentally incapable person who takes care of a person who has mental issues. An accomplice uses force or coercion with an armed weapon and so forth. So these are very serious ones. Again, when you see first degree, we're talking about the most egregious. So the term penetration means into the vulva, penis, or anal part of an individual, and can involve cunnilingus, which is the stimulation of female genitalia with the mouth, lips, tongue, or something like that, or fellatio oral penetration, where a person forces oral sex on them from another person, or anal intercourse. So then we get into second degree sexual conduct. The term sexual contact is as defined as the intentional fondling or touching of intimate parts. So those are the key issues. But prohibits a person from engaging in sexual contact under the same outlined above as first degree. But the term sexual conduct, second degree sexual conduct, is not as egregious. And sexual contact, though, is the intentional touching. Okay? Let's go to third degree. And then you begin to see that it goes down where they actually touched, massaged, and you could go down and you can see all of the elements of that. Then the fourth degree prohibits a person from engaging in sexual conduct under the same circumstances as in third degree. So they kind of tend to borrow from the same, okay? And then fifth degree. Now, let's get to, before we leave this, statutory rape. Statutory rape is a law that some people have argued should go away now because the times have changed, and that the way that people appear, they look older than they are, but it's there for the protection of minors. So statutory law prohibits intercourse between juveniles under the age of 18. The statutory rape laws vary from state to state. One constant thing is that the minimum age of consent is generally 16 and 18 years. And there's some difference in some states. Statutory laws are considered strict liability laws, which means that you can commit the offense without knowing. These laws don't require intent, but the mere act of engaging, only evidence has to be proved is that at the time the offense took place, that person was of a certain age and fell within what that statute defines as a minor. And these laws make it a crime to engage in intercourse with a person who can't legally consent, even if they do try, even if they lie. And in addition, it's never a defense to say that they consented because the minors can't consent under the law. Absolutely not. Due to the high nature of sexual assault crimes, many victims are unwilling to testify or come forward. And to address this well-known problem, most states have enacted, as I've already talked about, the rape shield laws, designed to encourage victims to come forth and without fear that their prior sexual conduct would be brought up in court. So, for example, a defendant will likely not be able to introduce the fact that a victim of a sexual assault is a loose person or constantly engaging in sex. Won't be able to do it because of the rape shield laws. Okay. Moving right along, there are key terms. Again, I already indicated to you, make sure that you study these key terms, and I told you there are various ways that you can do so. You can use flashcards. Flashcards is my favorite, and then they'll pop up in a screen here. For example, you can study these, and I encourage you to do so. Use the flashcards. They're the best to me. The intentional causing of death of one human being by another without premeditation, forethought, or planning. So you flip the card over and it tells you this: second-degree murder, or we call it, I told you, we call it voluntary manslaughter. Okay? Next. The intentional causing of death of one person by another when the homicide is done without any prior intent but occurs in the heat of passion, similar to adequate provocation. You flip the card over and you're going to find voluntary manslaughter. Voluntary manslaughter. Voluntary manslaughter. Okay? Then you go next. Established when two adults, at least 18 years old, live together, have lived together, or have a child in common. You know the answer to that. We just got to talk about domestic relationship. And you go on. To be indifferent or careless to the welfare of other people. Reckless. So you can do that, and you can go through and do each of these. Okay? All right? So that's how the key terms operate. And as again, I said, don't forsake them because they're very valuable in terms of helping you prepare for the quizzes that come up. And then special circumstances. Okay, and so you could go down, you could do the same thing here for practice. You click on special circumstances, and then it's going to open up a screen, and then it's going to give you, for practice, special circumstances. And then you can do the activity that's necessary to help you deal with that. So let's just go this for a minute. So here's a scenario. They'll give you a scenario here. It says Jane and Phil have been married for, and we're just about out of time, but been married for 10 years and have 2 children together. Jane also has a drinking problem. Jane came home drunk and argued with Phil. Phil threatened to leave Jane and take the children if she didn't get help. Enraged, Jane shot Phil and fled the house with their children. And then they say, which of the special circumstances would probably be claimed? Future dangerousness, coercion, violence, adequate provocation. So which of these would be? Try this one. Let's see what it says. Incorrect, because adequate provocation would likely to be claimed in this case because Jane was upset. So, therefore, continue. So it's adequate provocation. So you can do each of these, and then you have to make sure that you look at the the same thing. And you go into that, and it helps you as well. Okay? And if you get them wrong, you can do exactly what I just showed you, where, and then you got to make sure you read the fact pattern. That's another thing that helps you to get ready, because when you take these quizzes, you don't have 2 bites out of it. Okay? Trying to get to the bottom here. I'll cut off in a minute here. Okay. So homicide classifications, we've talked a lot about that. And then your practice quiz. So make sure you do that practice quiz. Don't skip it, because it's beneficial to show you. Just one question. Just one. Start the activity. The intent to cause death with premeditation is considered what type of murder? Involuntary, first degree, felony murder, or second degree murder? Let's see if this is right. Yep, the intent element. Okay? So make sure you go through and you pay close attention, because they help you to make sure that you don't miss the element. Then it tells you if you got it wrong, why you got it wrong, and those kinds of things. Okay? So that's it for the module. Now, I have also included your, and I'm not going to go over this because I already did, crimes against habitation, property, and assault. And if you go through, you'll be able to go into detail and deal with those issues from what I sent you. If you have any questions, feel free to reach out to me about that. And then criminal homicide, we talked in detail about that as well. And then this gives you an outline of material. And then the last one is dealing with sex offenses. So I've sent to you each of these PowerPoints, and each week I will send them to you. And I actually have covered pretty much these points in the lecture that I did today. Okay? So that's about it. So I want to remind you that I'm going to be looking for this word. And the word that I'm going to be looking for is homicide. That's it. Good night.